Is it a question and answer session? Okay, so what we're gonna do, I'm sorry guys, I just wanted to attend to someone's email before I start. So what we're going to do, I will answer some questions today. But first things first, I want us to talk about an issue that I see a lot, and you'll get to hear why I say it's an issue, and just so that you can see what you can do if it might affect you, because I'm really getting a lot of people who have the same issue. There's a lot of issues, but I think this one is one of those that it's one of those disturbing ones, right? Because when these things happen, people are often at a very disadvantaged position. So yeah, just give me 2 minutes. Let me send this, and then we'll get just to what we're talking about. Okay, so here's the issue, guys. It's a pity the other people fell off shame. Here's the what I want us to talk about. Good afternoon to those that just joined. Now, there's this thing, I'm going to make a scenario. A lot of people are married, and most of them in community of property, and some out of community of property. So what tends to happen is that these people often, they have kids. So what often happens is they don't draft wills, right? And some of them don't plan their affairs because they're expecting to actually live for a very long time. Now, this is what happens. Remember, I always say to you that what the law says is if you are married in community of property, let's start there. The way in which things are going to be split when something happens to one of you is that we're going to first look at everything together. I get it, you had a joint estate. It wasn't an individual estate. So we're going to look at everything the both of you have, and then we combine that. Then that is the value, right, of the whole joint estate. So then what happens after that is we calculate how much is half, because the half belongs to whoever is still alive, then the other half belongs to the deceased spouse. And then when there's no will in that situation, what happens is, or what the law says must happen, is that part of the 50% of the person that passed away, I agree, we've given the first one, they're still alive, they keep theirs. So now the 50 of this one, because they did not draft the will, what's going to happen is we're going to give them a certain portion. The spouse that's alive is going to get a certain portion. How much is that? So normally it will depend on how much is in the estate. For example, let's say it was 500,000 rand, and let's say these people had 2 kids. Example. What's going to happen is that the law says we must either give this spouse who is surviving 250,000 rand off that 500,000 rand. Let me repeat that. Remember, the one that passed away has a value. Their 50% is equal to 500,000. So what the law says is we have 2 options. Number one, it's either we give the surviving spouse 250,000 rand as an inheritance, and then whatever is left, we divide and give to the kids. If, however, 250,000 rand is less than, for instance, if we divide the 500,000 rand by the kids, including the spouse, if we take that amount and divide it by these 3 people, and that amount which we get is less than 250,000, we're gonna give the spouse 250. But if the amount is more than 250, like the amount of kids plus the spouse makes the money even much more than the 250, we're gonna give them whatever it is that is more. So what tends to happen in this situation is that the spouse that's remaining tends to get a lot, because of this. They get their share, and then they also have to get 250,000 rand. In this instance, I made an example and I said This is a 1 million rand joint estate. This one that's alive got their 500,000 rand in terms of the marriage. Then the other 500,000 rand that belonged to the one that passed away, the remaining spouse also had to get from that 250,000 rand, which means what? Those kids that they have are only now entitled to what? To 250. So this one literally got a share of 750 out of the million. Now, the issue then comes here. Normally, when the other spouse is remaining, they will want to get another person. They'll probably want to get married. Now, what then happens is that as soon as they get married, now they bind everything that they had. Remember, they got 750,000 rand in value. They are 50% plus now what they inherited. What they tend to do is now they get married, mash up everything with whoever it is that they get married with. And in these circumstances, normally you'd find that there is a property. So which means that it also now goes into this joint estate, becomes like this. Now, in the kids' minds, because the mom, let's say, has passed away, the dad is now remaining, the dad is the one that is getting married, in their minds, they think that they're still entitled to a lot of the things because, the mother was the one that got married to the dad first, etc. But what tends to happen is that they often don't have much entitlement. 250,000 rand, often they will get in the form of assets. The other assets, or if there's money, they'll get it in the form of cash. And in most instances, the remaining spouse will take that share of the property if there was an immovable property, which means that they inherit 100% of the property, and then the kids will get, this share either in terms of money or they'll get it in the form of other assets. Now, when this marriage comes about, it means now that this spouse owns the property with the new person that they are married to. So those kids, don't anymore have an entitlement to that property. Now, this is where the problem is. Because if the person now who's married to this mother or father of these kids, it's easy for them to kick those kids out of that property. And it has happened so many times. Because what happened? The spouse inherited 100% of the actual property. Do you get what I'm saying? So that's a disadvantage for kids because they lose entirely. Now they don't have what? A roof over their head. It even gets much more messier if the remaining spouse, who was their parent, now passes away. Because remember, we still have to follow that same cycle. And majority of the time, even this one that's dying, the second dying spouse, will still not have drafted anything, which means that the one that's now remaining, who is the new spouse, will inherit half because it's their joint estate. Then they will also have to inherit in terms of the law. Like we said, either the 250 or whatever the case is. But one of the things that you'll notice is that the kids normally don't get much. And whatever it is that they get is not really of value. And the spouses normally will take the whole property, immovable property. So which means kids lose their homes. So you'd find when the second spouse, who passed away now, because now the parents are gone completely. What tends to happen then is that this person who was married to these kids' parent, whoever was remaining, is going to kick those kids out of that property. And they have the right to do so because that property is theirs. It is not in that family anymore. It moved by virtue of the law. And the prime reason for this, no one was drafting a will and people were just getting married and just mashing everything up. Now, we get a lot of people who approach us and say, but I need to get entitlement. It was my father's property. It was my mother's property. But then you explain to them, the situation has changed. It moved with inheritance. So it's no longer that property that belonged to your mother and father. They may have been the first people to acquire it, but because they never had anything in place, gone is that property. Did you get what I'm saying? It's no longer in the family. And this is a very hard pill to swallow because it means those kids lose a home entirely. It moved from a certain family and now it's gone to a totally different family. Those kids have no relation to this person. This person was a step parent. Step parent gets everything. A lot of people try to fight this, but I will not lie to you. This is a battle you will never win because it is the law. That's why we always say that if you have kids, you're married, and all of these things, you must say something. Draft something. Let your kids get a share. Let them get a share in that property. Make it difficult for the spouse that's alive to do as they please. The spouse that's remaining also will side with the new spouse, this new step parent, and kick those kids out, and those kids will try to get some form of relief. But then when you talk to them, you're like, there's no relief, my baby, because everything is gone. You get what I'm saying? Your parent was remaining, and this new person are now the owners there. They have a right to decide what they should do with their own property. And things change as soon as the first parent passes away, because again, people have to remarry. They remarry all the time. This is where complications come. So as a parent, you are not at liberty to not draft the will. You are not at liberty. It doesn't matter even if your kids are over the age of 18. It's a must for you, because number one, life changes. It hits kids as well. It hits everybody. Everyone needs a home. Today you could be doing good and then your parent, and this is also another issue. Because they see that now the kids are doing well, it doesn't matter. And then they will not prepare still. They will not ensure that, this property, it must still be for them, so that if something happens to them, at least they have a place that they can run to. Even if now they can rent it out or whatever, but they must have something. That's also where people get relaxed. I tell these kids, they will be fine. They are okay. They are working. They have degrees and stuff. Life hits people. Sometimes it's not even anything that they've done. Maybe health-wise, finances may change, whatever the case is, and they will need a home. So if you want to protect your children's interests, you will try to draft something. In fact, you will not try. You will draft something. In that way, you'll ensure that their interests will always be protected. Otherwise, those kids now have to find another place to live. And here's the thing, who can really afford a house in this day and age? It's not easy. Even if you are working, you're earning enough, it's not easy for people to just acquire property just like that. So draft something, because you complicate things for kids and you put them in a very difficult situation. I've seen so many kids cry, not even kids, like we might call them kids, but they're adults. I've seen so many of them crying because of this kind of situation where they lose their property or the property of their family through these kinds of subsequent marriages, that happen, and the lack of planning, the lack of drafting anything. It really is a disadvantage, especially within the Black community. To this day, a lot of people are so comfortable and are so relaxed when it comes to things such as will. But then the weirdest thing is that they will never not prepare for a death, because they will definitely have a funeral plan. But then people struggle to see the importance of drafting a will, which is something that's going to cater and protect the interests of people for a lifetime. Because that will is going to protect your kids' interests for a lifetime, not for one day. Funeral money is very, I don't want to say useless, but it's not really useful in the lives of the people you are leaving behind. So that's what I wanted to tell you about before I answer your questions. So you need to be cognizant of your situation. and realize the fact that you don't have time. Just like you see it in the context of a funeral cover, you must see a will in that context, that anything can happen. So as you're talking about and thinking about a funeral plan or a funeral cover, you are also, on the other hand, thinking about sorting out your affairs, drafting a will. So that's what I wanted us to talk about. So I'm going to answer some of the questions as we go along.